out what to do in cases of fragmentation. And there, the natural law tradition would be insisting that it's not that it's a free-for-all for the judges to simply apply their own preferences in interpretation, but rather they should be guided in their interpretation by natural law premises. So, for instance, some are saying that a pro hominem interpretation is appropriate, that they want to choose an interpretation that best furthers the interest of the individuals affected, rather than, say, the interest of the state affected. So that would be, again, an expression of this commitment. And by focusing on how does this affect individuals systemically, that expresses then a way to ensure increase the legitimacy of public international law. Some of the other historic roles that this natural law tradition has played concerns issues when existing positive public international law lacks legitimate authority. So what do I have in mind? When there are laws on the book where there is no moral obligation to defer by the standards of natural law theory. So it's not, again, we have to be careful here, it's not, the position is not that if a law is not normatively legitimate, we are always justified in disobeying. There may still be reasons to obey or defer, even though the law itself is not legitimate. Why is that? Because there may be lots of other reasons we have to comply than the fact that it's an authority that issues it. Others may be relying on this, right? So we may have obligations towards others, not because of the stupid authority, but because others have created expectations. Or because by violating this, we might actually do evil, contrary to the sociability requirement. Others may have expectations. There may be risks of leaving to each actor the discretion to decide whether to comply or not. So the natural law tradition isn't saying that revolution is always justified, but only that we have to be careful in those cases. But it requires complex arguments in there. And it may be required from the natural law tradition to say, well, even if you're disobeying, you should still try to show that you're generally respectful of public international law. And then, yet another role is when there is no public international law, but where natural law theories would say, well, there should be some kind of legal regulation of issues. Then, sometimes the natural law arguments would say, well, there should be public international law, where environmental issues might be one case. So there are reasons based on the impact on individuals, features of individuals, to regulate the environment through more binding international law than are current. There's also cases where the natural law tradition is saying there are some norms that we should comply with even when there is no enforcement. And so when there is we can't be sure that others will act accordingly. And historically we see this in how the Spaniards, by natural law standards, were supposed to treat indigenous groups in the Americas. So respecting their property, even though reciprocity could not be expected. There are aspects of universal jurisdiction, as we would call it now. How to punish when nobody has the explicit delegated authority to punish. Several of the natural law theories are saying there's an obligation, a right to punish, even sometimes an obligation to punish certain violations of law. And the rules of war, again, carefully crafted by some of these, knowing that you can't be sure that your enemy will respect the same laws, but still there may be some constraints on what you could do in going to war and how to conduct yourself in war. So, third step of this article, out of this presentation. Let me now look at some criticisms against the natural law tradition that's been voiced fairly recently. And I'm interested here in saying, how well does this limited family of natural law theories that I'm thinking of how can that stand up to the criticism? Right? I don't want to defend Vattel and Pufendorf and all of these guys. I'm interested only in this narrow that has this modest set of premises about human nature, and that contributes to some of these topics historically. Just to make clear, on this account, the natural law theories are not making some claims that are sometimes assumed to be made by natural law theories. It is not, these theories are not explicitly based, say, on theological premises. Some criticism against natural law theories are that, well, they're based on a belief of God and what God wants with human beings. And I'm suggesting very many of these theories explicitly try to avoid what we may think of as sectarian premises. They may still have believed that there was a God that gave, that created the world and so forth. They believed that there was empirical grounds for making that assumption. Right?
Even the early guys?
Pre-Darwin and so forth. Some of them recognized, yes, this is, we have reason, we look at the world around us, it's so complicated, it must clearly have been created by a creator. Right? So an attempt at an empirical premise, but we also find very clear assumptions, say Thomas Aquinas in the Summa contra Gentilis and others, recognizing we cannot assume that they share revelation. Right? So it's a commitment that has found different expression over centuries. So they're looking at what is regarded as agreeable, somewhat empirical premises. So we see this very clearly in several of them. Other critics are claiming that natural law norms are completely immutable, that they're unchangeable. Again, I think this needs to be adjusted. I think one of the points is that the standards that are laid out by natural law theories cannot be changed simply by states agreeing or by individuals agreeing to positive law. The point of this is to provide some kind of standards for assessing positive law. But there are a lot of changes to those norms that we might regard as epistemic improvements. We have come to discover that also women can reason. Right? So that means we need to shift the premises. Right? We have come to understand that indigenous peoples also have cultures worth respecting. We have come to believe that nobody is somehow naturally slaves when it comes to the capacities of the relevant kind. Some of the theories were not good at distinguishing moral norms that should regulate interpersonal behavior from the norms that should regulate laws. That's, again, an improvement in the quality of the reasoning. Some of these theories would be more careful in saying the features of human beings that we can take as granted among each other needs to be selected with a sufficient understanding that we actually disagree on quite a lot of these things. We don't all agree on the value of knowledge, unlike Finnis. Right? If you're a professor of philosophy, of course you value knowledge, but there aren't enough philosophy professors around to make that a sort of shared assumption. Right? So that you need to adjust the features of human beings that will count, or you have to adjust your understanding of the role of law in light of the fact that there's reasonable disagreement. So some of the theories are more careful about that than others. And I'm suggesting that the narrow theory that I sketched tries to be minimal in that set of controversial premises. And then there are some changes that are due to simply that we now have institutions that can handle such stuff. For instance, we have international courts that can deal with adjudication, that can apply shared norms in a more impartial way, so that we now know we have some kind of independent standard for assessing whether there's a violation of a free trade agreement or not, which you didn't have before you had these institutions. So you could monitor free riding. You have institutions that can regulate and manage shunning as a new form of sanction for international law, and so forth. So there are many reasons for saying that the norms of natural law might actually change over time due to these changes in institutions, in our knowledge. What we discover is actually reasonable disagreement. But again, so that's possible. Another point to make clear about with regards to natural law is that natural law theories are not claiming that illegitimate valid laws are not law, which is sometimes assumed by some of the legal positivist camp. So the concern for natural law theories is that why is it that positive law actually enjoys sometimes legitimate authority? And what are the conditions? When do subjects have a moral obligation to obey a legally valid law? So that's the main concern. So that's the sort of question which I understand legal positivism is not aiming at answering. International legal positivism is not aiming at addressing the issue of the legitimate authority of law. So we see Hart expressing very clearly whether a legal rule is valid has nothing to do with whether that law ought to be obeyed. Right? And so Hart's concern about validity has nothing to do with obedience to it. While the natural law tradition, as I'm laying out, is taking that question as a central issue. When does valid law have any claim to be obeyed? So the natural law theories, as I'm suggesting, has a very different sort of question than legal positivism, where legal positivism is concerned about, so what counts as valid law? Not at all addressing issues of whether it merits obedience. So on this account, and I'm not the first, would be saying that Hart is mistaken when he claims that Thomas Aquinas is saying that man-made laws that violate these standards of natural law, that they are not valid law. Aquinas isn't denying that it's valid law in Hart's sense. He's saying, Aquinas and the others in the natural law tradition are saying, it may be valid, but it has no claim on us to be obeyed. So, and Waldron, again, I go on and on about some of these objections. Waldron says natural law cannot function as law in the world. It's not enforceable and so forth. And I'm suggesting the roles of natural law that I've sketched out, most of those can be provided very well without natural law functioning as law in the world in the sense that Waldron is concerned with. These constraints and the guides on what positive international law should be agreed does not require, those standards do not require that they can be enforced. Waldron says natural law theories are producing, a set of moral criteria for evaluating positive law. Yes, so that is one central role of natural law. Now, Waldron says, of course, the positivist can do the same. He's claiming that the natural law tradition says that to call something law is called into question if it doesn't satisfy those criteria. I'm suggesting no. Natural law tradition is not saying that it's not law, but it's saying that law has no claim to be obeyed. So it's a different question. So it's a very different understanding in Waldron and Hart of what the natural law tradition is up to compared to what I've been suggesting. And of course, Waldron is saying that the legal positivist can come up with some kind of standards, moral standards for when positive law should be obeyed. That's a very interesting account of what legal positivism is all about, because as far as I can understand, that's not a question that legal positivists theories try to answer. Legal positivism can be supplemented by such moral standards, but it's not something that's intrinsic to the purpose of legal positivism. So I'm suggesting one conclusion here is that there's a false conflict between legal positivism and natural law traditions, as I'm sketching it up. And again, I'm not the first one to say it. Some of the natural law theorists which started this for centuries. Natural law is arbitrary, controversial, as an objection. And again, here I quite agree, but we may want to scale down the criticism. Certainly, many of the claims that are said to be natural law claims may appear arbitrary. Critics are correct, I think, in saying that much of the legitimacy talk that has natural law resonance appears fuzzy and is very little more than the moral intuitions. What do I have to say in response? I'm not interested in those who are making normative claims. I'm not interested in Vattel. I'm not interested in Trindade. I'm interested in theories that are trying to identify premises, good arguments, and consistency. So that's not a challenge, that's not a criticism that necessarily goes to the theories, though it may well affect some of the claims that are being made. And again, if we want to talk about arbitrariness, we need to say, well, so compared to which other moral theories, say, the Waldron was suggesting, could be supplemented to provide more normative standards. So the final, is this okay? The final set of challenges and crises. And again, all your suggestions for what to add, what to cut are most welcome. There's the legitimation challenges of positive international law to some extent. That seems to be a challenge, whether it's a crisis. I think that's maybe overselling it a bit. I think the natural law tradition may help frame the sort of criticisms that are raised against positive international law and international courts, partly by facing straight on, so what's the purpose of public international? What functions should these norms serve? What roles should international courts and other international legal bodies actually provide? And so one of the shifts from the dominant discourse in some of the legal discussions is that that's provided by the natural law tradition is the purpose and the ultimate justification of public international law is not to always promote the interests of states. That's not the point of public international law, according to this tradition, but to promote and protect individual human beings. And it's when there's a discrepancy between those, that's the sort of legitimacy critique against public international law worth worrying about. So the criticisms, again, going through this, I'll just sketch this, that it's ineffective, that public international law doesn't secure compliance. As a critique, this might go both ways. One could argue that it's exactly when there are no sanctions that legitimacy talk might actually be more important. Because then the question is, what reasons do states have for complying with public international law, with international courts, if there are no sanctions? And so if compliance is important, then talk about the legitimacy, what reasons these courts actually have, these international legal norms actually have for commanding compliance. That topic becomes even more important. Issues of non-compliance. One of the possible challenges to public international law might be a particular kind of non-compliance. Not the fact that some states aren't implementing particular judgments, but the principled non-compliance. Again, not by the nasty authoritarian governments. When the German Constitutional Court says we might counsel non-compliance with the European Court of Human Rights if it violates the fundamental principles of the Constitution, which are not where the fundamental principles are not written down, but that somehow the spirit of the Constitution. Or here in the UK, if when there are public expressions that we might not comply, if truly fundamental principles of our law, left unspecified and not written, are at stake. So those challenges might be more sort of threatening by generally compliant, law-abiding states. Or when generally law-abiding states engaged in what is often referred to as illegal but legitimate humanitarian intervention. What are we to think about that? And then I would suggest international natural law traditions have something to say. They might, for instance, say, in principle, we can acknowledge and accept international civil disobedience, official civil disobedience, as a kind of protest against what appears to be deeply illegitimate public international law. But then insist that we want arguments. We don't just want the German Constitutional Court to say, sorry, this is against our fundamental principles. We would want arguments to show, so why is this principle, this fundamental principle of our law, why is that worth respecting? What's the foundation of that, justified then on the basis of human nature and those features? And where the risks of this sort of compliance is taken full on. Does it risk unraveling what little respect there is for public international law? What are the risks of abuse of this? Are you prepared to say that less rule of law committed, less democratic states are also free to say, well, this is against the spirit of our Constitution? We have other examples than those two countries that are saying this at the moment. But engaging in those arguments and insisting that we want justifications, not just somebody saying there's a principle at stake. A third challenge is renationalization. Several states are pulling out of international treaties, international courts, the International Criminal Court, the European Court of Human Rights, the European treaties, trade agreements. What are we to think about it? So from the point of view of natural law theories, unlike some other normative theories, the states may in general be quite legitimate. Some scope of sovereignty may be legitimate. And there may be value that's important to take seriously about individuals living together as compatriots who want to share a common life. Right? The sociability argument. People want to share interests. And from this point of view, there might be a lot of treaties that are optional in the sense of normative. If there is a preference in a state to join for trade reasons, to enhance investment, this is normatively unobjectionable from the point of view of natural law theories. Again, speaking as a Norwegian, whether to join the European Union or not may arguably be one might be normatively agnostic from the point of view of natural law theories. Leaving a system, however, and how to do this procedurally is another issue. And there's no reason to believe in principle that public international law is legitimate. That's an open question. So from that point of view, natural law theories might agree with third world approaches to international law, that there's no reason to believe that even though the public international law brings international order, that makes this into a just or equitable or legitimate code of global governance. So that's an open question, also from the point of view of natural law. Where it would disagree with some proponents, some of those who want to renationalize, is to insist, well, the justifying purpose of states, of sovereignty, is not only to promote one's own citizens. There are constraints, the norms of sociability, including some kind of low-cost assistance for non-citizens in need. So some treaties might be normatively required from the point of view of natural law. Protection of human rights. If human rights respecting countries sign up to treaties that benefit the human rights of citizens living in less human rights respecting countries, like arguably human rights treaties do in some regions, climate and so forth, that might be required. So that might be a constraint on how states should exercise their sovereignty. But again, and here's a weakness of this sort of international law theories, they're not very specific. They're not going to explain in particular, for instance, how these very complicated divisions of burdens and benefits of trade or of environment should be distributed when there are alternative rules for dealing with the collective action problems. And there are several different norms that again need to be balanced more carefully. Not only do no harm, but also one should be contributing according to ability and so forth. Fragmentation, I'm almost finished. Fragmentation and interpretation of public international law. I would suggest that natural law theories can help at least indicate how to deal with some of the alleged problems of fragmentation and multiple interpretations. It's not obvious that all fragmentation is a problem. It's not obvious that all gaps are problems from the standards of public international, of natural law theories. One of the central questions is which modes of harmonizing fragmented international law are to be normatively preferred. So for instance, should the European Union treaties be subject to the European Convention on Human Rights, or vice versa? Honorable authorities in charge of each of these treaties respectfully disagree. That's a diplomatic phrase, is it? Where the risk, in part, is that these judges have extremely much influence through their own discretion about how to harmonize. And how to do that, again, the natural law tradition might join, I think, the critical legal studies and the Twale approach, saying that it seems clear that public international law has always been an instrument of domination by Western states. This is a new mode of imperialism. And this fragmentation and the possibilities of interpreting in different ways and balancing in different ways simply increases this vulnerability of the weak. And certainly the natural law tradition has contributed. We see Vattel and others in this tradition have contributed to create a system that is designed, if not foreseeable, then clearly with clear implications for us. So that the natural law tradition might contribute to this in part by helping reconceptualize, I would suggest, those risks and the proposals for how to harmonize. So again, from this point of view, the problem is not that judges will adjudicate or interpret different from what states have consented to. That's not the sort of agency drift that's the deep problem from the point of view of natural law theories. That they will deviate from what it is that gives public international law legitimate authority based on human beings' interests. So that's the sort of agency drift. That international law should be focused on promoting, respecting the impact on individuals. So that's the sort of constraint that's important. So that would be a way that I would suggest that natural law might strengthen the criticism that we sometimes find from Twale and others. And I think that is a sort of contribution that natural law theories could make to critics who are often themselves criticized for being only destructive. So natural law theories, I would suggest, could help justify why is this sort of domination problematic. Why it should be a major source of criticism, what sort of domination, what sort of arbitrary discretion is of concern, and what would count as an improvement. Again, areas where some critics of the 12 criticisms are saying this is those observations are only destructive, they're not constructive. So conclusion, I'm suggesting that states have played prominent roles in public international law and in establishing positive legal norms. This is nothing new. But there's a risk that people believe that the purpose that makes public international law legitimate is to promote the interests of states. And the natural law tradition is insisting that is a fundamental mistake. The justifying purpose of public international law must be to secure and promote some features of individual human beings. That's how these institutions are legitimate. In complex interaction with other authorities, including states. Again, where sovereignty constraints may be quite justifiable, insofar as that's necessary to promote human beings. Features as listed by these natural law theories, where sociability then is one component. And where natural law theories, stressing theories, is focused on the arguments and the impact from very clearly stated premises. And I think by focusing on these arguments, that might help natural law theories, or at least some of them, avoid otherwise well-founded criticism that legitimacy speak is very fuzzy and indeterminate, and it's only sort of expressing our own moral intuitions. That might be true for some legitimacy talk, but I'm arguing that natural law theories of the kind that I've suggested will avoid those sorts of criticism. But instead, opening the debate about, so here are some natural law arguments about this. Again, the philosophers will say, and there are other theories about how to justify it. But again, those sorts of discussions are extremely important, partly, I hope, to help alleviate some of the challenges to public international law. So that's what I would like to have feedback on. Thank you so much.
Thank you very much.
Apologies for I spoke far too much.
Please, is it okay if I will be sitting here? Any questions? Comments? Yes, please.
Yeah, so thank you for the talk. It was really interesting. I'm coming at this really from a third world approach. So perhaps you might have already covered this and I've not quite picked up on it. But I think the problem I have with your argument is that if you view natural law as being a legitimizer of international law, in this sort of very base sense, then where natural law legitimizes the domination and subjugation of third world states in this new way, in this non-classical imperialism, then the critique of the positive order of international law can also be applied to any natural law underpinning that positive law. That, I think, is quite a powerful retort to this idea that this is in any way definable or legitimate. But I would be interested to hear what your thoughts on that are specifically.
Let's see, so my intention was to say, so this sort of natural law theory would help justify the Twale criticism, insofar as international law is actually violating, say, norms of sociability. Insofar as current public international law violates, actually makes some people worse off, or prevents some peoples from flourishing, natural law theory is saying this part of public international law is illegitimate. It does not merit deference. So that was what I meant to say.
Okay.
But I've clearly, if you agree on that, then I have to rephrase what I'm saying.
It perhaps is my misunderstanding rather than.
No, but so that is very helpful. A very helpful message back to me.
Yeah, I mean, I want to carry on with this question, because my first reaction, I think, was that, oh wait, this is possibly that how do I say what I'm saying? Okay, I think your reasoning, it makes sense to me. However, it assumes that the third world perspectives are willing to accept the basic premises of natural law, which is that I think this is where potentially the largest critique is that they may not start with the assumption of the individual. And if that's the case, then I'm not sure they benefit from a natural law tradition. If the individual has to be so central to the natural law tradition, the results may be that it supports international law that is not. I think in the outcomes, it may resemble some of what the Twale perspective tries to argue for, but I don't think it actually benefits on the basis of its premises. If that makes sense.
Well, so one example then would be, you could have normative theories that are saying, well, the communities or peoples have sort of intrinsic value, but that is not ultimately based on the value of the individuals who constitute them.
Yeah.
Right?
So, but is there much in the natural law traditions that assume it's so that doesn't build from the idea of rationality that's based on the individual?
No, my understanding of the natural law tradition that as I've sketched here, is that it's always somehow saying, well, it's the interest, the justification of peoples, the authority of peoples is basically boils down to peoples as institutions have value because of what they do for individuals. But of course, many of the interests of individuals are interests in doing things to social